Chief Justice Winkelmann. You're our 7th guest on this series on judging and social cohesion. We've kind of toured around Asia with this podcast, and occasionally we do make detours outside of the Asian continent, and today is a detour. And Mario, don't you agree that we'd much rather have this conversation in beautiful New Zealand?
Oh, absolutely. It's such a beautiful country. I was there many years ago, and I love the South Island.
Singapore and Sri Lanka aren't too bad either.
Yeah, so if you don't mind, Chief Justice, we'll just get on with the conversation.
Yes, go ahead.
So thank you very much, Justice Winkelmann, for joining us on this edition of Tri Chats. We appreciate your time. I want to start by asking you about diversity and social inclusion within the judiciary and the legal profession. You've been a champion of diversity and social inclusion, especially with regard to the Maori and women. Could you speak to us a little bit about some of the challenges and the obstacles you faced, and also about some of the achievements that have happened in New Zealand over the recent years?
Certainly. Well, I mean, if I might just back it up a little bit and just spend a moment to talk about what I mean when I speak about diversity, because I think there's a lot of value in defining terms for yourself when you're setting out on a pathway to try and improve the diversity of your judiciary. When I speak about diversity, I mean that in two main senses. First is that the judiciary should be reflective of its society, so it should look something like the society that it's serving. When I was at law school and I was a young lawyer, our judiciary was made up entirely of, what seemed to me at the time elderly, but now I wouldn't say so probably, but white males in their 50s and 60s. So there's that sense in which it has to be diverse, but there's also another sense which I think is important, which is that it has to bring the judges as a whole have to have a sufficient knowledge base of their society and an experience that as a whole the judiciary has knows its society in a way which means it can serve that society. So those are two senses in which I speak about the notion of diversity. So I pursue both in the work that I do, and we've begun trying to measure it. We first started measuring what our judiciary looked like in terms of its gender, culture, work and life experience in 2021. And our recent report showed us that we've got to 46% of our judges surveyed in our most recent report are female, which is up from 35% in 2019 from what we could tell at that time. So that's great. Yeah, that's great. But so gender equity we can't say it's done. We have to keep not a tick box thing. We have to keep an eye on it, but we have to think about other things now. I think the two most significant challenges for our judiciary are in the areas of cultural and socio-economic diversity. And in that, the challenges and issues are different. When I speak about cultural diversity, I think that our judiciary does not currently adequately reflect the ethnic and cultural diversity of our population. New Zealand's population is predominantly European, 68%, but it has approximately 20% Maori ancestry, so the indigenous people. Another 17% of the population is Asian, and that percentage is rapidly growing. And 9% is what we call Pacifica, which is from the Pacific Islands. But that diversity is not reflected in our judiciary. Pacific and Asian judges are particularly underrepresented. Only about 2% of judges surveyed were Samoan, for example, and only 1% were Chinese. We've got, not doing so badly in the Maori front, we've got about 21% of our judges are Maori, but then again, we've got to be conscious about where those numbers are made up. They're in our Māori Land Court, which deals with Māori land title, and in our district court, and only 12% of our judges in the senior courts are Māori. So that's something we're focused on. In terms of what the answer is for this type of diversity, I think we have to be mindful of ensuring that the practitioners who are coming through, and they are coming through the profession in numbers, are getting a sufficient type of work experience to fit them for serving on the senior courts, because that's where our most significant problems are. So people are tending to over-specialise in some areas so that they don't have the breadth and depth of experience in difficult legal areas, complex crime, complex commercial. And so we've got to support practitioners to understand what's required there.
That's great, Chief Justice. And what about the socio-economic dimension then, especially when it comes to the judiciary?
Only a small proportion of our profession comes from what we call a poor background in New Zealand. And our judiciary is probably not that bad as we sit here today in terms of reflecting a mixed socio-economic background. That's because our judiciary is made up of people who were at law school in the 70s, 80s, and now starting to see people coming through who were there at the 90s. That was at a time when the financial barriers were not so great. And so we were definitely getting a mixture through from people from poorer backgrounds. But now we know that that's no longer true, because there are greater financial barriers to people getting into law, and because there are less financial support to go into university. And it's been reported that in New Zealand, 60% of students accepted into our law, medicine and engineering faculties came from the richest third of homes, and only 6% came from the poorest. And that's of concern, because you want judges who have some understanding of the experience of those who are at the most disadvantaged in society.
Absolutely.
Yeah, to some extent you can get that by getting people who've represented them through the course of their life, but it's best if you have a mixture. So part of that barrier is to legal education is financial, but we also think that part of it is that there's a sentiment amongst children in low socioeconomic areas at schools that law's not for them, that the courtroom is an alien environment, and that the judiciary is, made up of people who come from a different background to them. So we've really got a task there to break down those kind of misconceptions, preconceptions, in terms of to support people from lower socioeconomic backgrounds into law. And we've got work programs that are directed at all of these issues.
That's what I wanted to follow up on, Chief Justice, because I find that to be quite interesting. What are some of the initiatives that the judiciary has engaged in to kind of close this gap, or this perceived gap in perhaps what can be called socioeconomic classes when it comes to the legal profession?
Well, we have a number of work streams, but we work with the universities to encourage them to focus on supporting students from less well-off backgrounds through law school, because there's a lot of advantage embedded in the fact that you come from a wealthier home. You have connections, you have a better understanding of the power structures within society, but also you have less demands on your time, less competitive demands on your time, you don't have to work in a part-time job, for instance. You don't have caregiving responsibilities. So we've asked universities to step up and provide more support and more mentoring to children from poorer backgrounds as they come into law schools. We also support programs being run by private law firms, which are reaching into the schools themselves and talking to students about law as a career path. And one law firm in particular, which is our Crown Solicitor, which is the Crown Prosecution Service in Auckland, has got an entire scholarship program which starts off with education programs in schools, then gives scholarships to students and supports them through access to IT, access to mentoring by young lawyers, and work-life experience in a law office. So kind of recreating those kind of networks and supports that children from better off backgrounds have.
Fantastic. So on this issue of diversity and the law, Chief Justice, I suppose one of the inevitabilities is the interaction between the various legal normative orders in New Zealand, common law statutes, indigenous customs, And the court has been at the forefront of dispensing justice as legal claims or legal issues evolve over time. So practically, how does the court navigate these multiple bodies of law? I mean, I can think about the recent case of Smith versus Fontera on the issue of climate nuisance. Could you speak a bit more on that, Chief Justice?
Yes, certainly. Well, as to how we navigate it, we navigate with care. There are all sorts of considerations in play. I probably need to mention that, as I said earlier, about 20% of New Zealand's population, we call it whakapapa Māori, which means that they link to Māori ancestry. And many of the customs that regulated Māori society when Europeans first arrived in New Zealand continue to regulate the lives of Māori. It's therefore right to say that issues as to the interaction between tikanga and New Zealand's other sources of law, which are common law, which was brought over from England by the initial English settlers, and statute law are inevitable. And that's reflected in the fact that for decades now, Parliament has incorporated tikanga concepts into legislation. Tikanga concepts are, indigenous laws often have quite different framing of concepts that are in large part quite familiar to us from a common law background, but they have some other characteristics. So there is in New Zealand tikanga, there is a very deep connection between family and the environment, and environmental factors carry a personality in this framework, and the individual families and tribes have responsibilities to the landscape as if they were members of their family. So these kind of concepts have found their ways. Tikanga concepts have found their ways into the statute books, and judges are required to apply them in their decision making, particularly in the areas of Māori land, certainly, the environment and family. But the courts have also recognised, flowing on from this, that the tikanga can shape the common law that affects not just Māori, but all New Zealand. And that's because Māori are a very active part of our society, and they're, 20% of population, very active part of the economy. The values that they espouse and regulate their lives with inevitably start to imbue and shape the rest of society. And we have a concept, for instance, called mana, which is your standing and stature within a society. And, if all New Zealanders would understand what mana means, and those are the kind of concepts that inevitably start to colour our common law. So going back to the case you mentioned, which is Smith and Fontera, that's the kind of case that we're seeing before the courts, in all common law jurisdictions. It's a climate change piece of litigation. But what's different in New Zealand is that the plaintiff, Mr. Smith, is a Māori elder, and he's a climate change spokesperson for a national forum of tribal leaders. And he brought a claim against 7 of the largest emitters of fossil fuels in New Zealand, alleging that those emitters had materially contributed to climate change, and as a consequence that they damaged and would continue to damage areas of land and sea of customary and spiritual and nutritional significance to him and his whānau, his kinship group. The word whānau means family or kinship group. His claim was struck out in the lower courts on pretty much traditional tort law basis, because it was said that, there were issues of causation and causation in the area of climate change, and also that he couldn't prove special damages. He appealed, though, that strikeout all the way to the Supreme Court, and all he was seeking in the decision that we issued in the Supreme Court was the right to continue with his claim to try to prove it.
So I understand that the Supreme Court allowed his appeal. What was the reasoning there, and where does tikanga figure into all of this?
One thing that we said, which you're starting to see in lots of jurisdictions, was that the court said the statutory framework for regulation of climate change greenhouse gases didn't displace the common law of nuisance, and that Parliament had left the pathway open for common law to operate. As to Mr. Smith's pleading in relation to tikanga Māori, he said that it should inform the content of the causes of action itself, but also that it proved special damage on his part because Māori had a special connection to and relationship with the natural world. And he argued that the harm emitters were doing was causing injury to himself, his extended family, and his descendants. And the Supreme Court allowed the appeal, noting that, and in doing so, we noted that tikanga had been applied to tort actions since the earliest days of common law's operation in New Zealand. Of course, when those early settlers arrived, they were arriving in a country where there was this established way of living amongst Māori and regulating their own lives. And so when the European settlers interacted with them, the courts at the time often gave effect to tikanga concepts. So there's a continuity there. This isn't a new thing.
Right.
And they also said that the tikanga concepts he was relying on could be relevant to the issue of special damage, which is a consideration for sort of nuisance, public nuisance. So the development of tikanga as a source of law in New Zealand has implications for the judiciary, it has implications for Parliament, it has implications for our business communities. And I suppose it's a collective responsibility. As judges, we have to proceed very carefully because there has to be certainty in the law. We also have to proceed carefully because we have an obligation not to distort tikanga, which is a separate body of knowledge, which is based in marae, which is based in the home place of Māori. And so we're not responsible for generating it in our courts. We're responsible for appropriately reflecting those values that are practiced in our society in the common law. So we have educational programs within the judiciary for judges. And the law schools have passed a resolution that they must also now start teaching law students tikanga Māori. So it's going to become a compulsory part of all law school curriculums from 2025. And our Law Commissioner, which is our law reform institution, has issued a report about how recommending a pathway which would give certainty in the development of the law in relation to tikanga. So we do have an emerging framework, I suppose, is how you would describe it.
I want to build on that previous question by asking you more generally, there are a number of issues, I'm sure, that come up before the court, which may be termed polycentric or contain elements of social policy. How does the court respond to these claims, especially when maybe not all parties are before the court? How do you ensure that you stay within the doctrine of separation of powers when you deal with cases that have policy implications?
Yes, well, that's one of the hardest questions for any judiciary, I think. I mean, it might be worthwhile for me to say something about our constitutional settlement because New Zealand has quite a particular constitutional settlement. We don't have a written constitution, nor do we have a constitution which is supreme law. But we still do have the concept of the separation of power. So in New Zealand, we describe it as being branches of government as being codependent, but each sovereign within their own sphere of authority. And in this constitutional order, our role as judiciary is to apply the law to the individual case. So that would be familiar to each of you in terms of your own jurisdiction. So the judiciary applies common law and statute. So Parliament is sovereign. If the courts issue a decision which is not liked by Parliament, they can overturn that decision at any time, but the courts, for their part, don't have the power to invalidate acts of Parliament. All the same, our society still subscribes to the rule of law, and to secure that, you need an independent judiciary. So that's the constitutional model we operate within, and one of the things that helps us navigate these quite tricky waters without a written constitution is the principle of comity, which again is a common principle amongst common law countries, but it's got real bite in New Zealand, where we're navigating a complex constitutional picture without a written constitution. And this requires judges to stay out of the zone of Parliament and the executive, but on the other side, for the executive and Parliament to respect judicial independence and not to take steps which would undermine it. I thought what might be quite interesting is if I talk about two areas that that you see polycentric, complex, sometimes publicly controversial issues playing out, in which Parliament and the courts have a role, and an area which is always controversial in society, in every society, is sentencing law. And I think in New Zealand you really do see the collaboration between the branches of government here. We have a Sentencing Act, which is Parliament's guide to the courts about how we have to sentence people, and it sets out these principles and purposes of sentencing. And it says the courts must be consistent in their sentencing, they must protect community, they must provide for the interests of victims and hold offenders accountable and deter other offending. But they also require that the courts impose sentences that assist the offender in rehabilitation and enable the offender to be kept in the community if possible, if that's practicable. And then they also recognise that personal circumstances such as age or mental health might be relevant to the offender's culpability or their likelihood of rehabilitation. So I think as you listen to that list, you'll see that some of these things pull in different directions, and there's no guidance as to how all these considerations are to be weighed up. But what it does recognise is that judges have an important role in making sure that justice is done in the individual case, but making sure also that sentencing serves the needs that society as a whole needs them to do. And what the courts have done in response to this is create our own frameworks, statutory frameworks, our own guidelines which sit on top of those statutory frameworks to give guidance to judges about how they exercise their discretion in this complex statutory framework to do justice, and allowing certainty as to consequence, but at the same time sufficient certainty of consequence and consistency, which is necessary for public safety and deterrence, but also sufficient discretion to judges to make sure that injustice is not done. And in a recent decision for Birkeland and the Queen, the Supreme Court reiterated that consistency and a full evaluation of the circumstances must sit together to achieve justice in the individual case. So that's really the courts taking a complex piece of legislation and navigating through to meet the needs of many parts of our society. And so I think that it's clearly true, to be fair, the law must be sufficiently general in its application, but it also has to be sufficiently flexible to account for personal circumstances in order to do justice.
Just wondering whether there are any further examples you could give us of this approach.
Well, there's another area that's, I think, where the courts sit in a complex space in our societal and legal order, and that's in respect of a piece of legislation called the New Zealand Bill of Rights Act. So while we don't have a written constitution, we are, as is Singapore, signed up to various international covenants, including the International Covenant on Civil and Political Rights. And the New Zealand Bill of Rights Act 1990 was New Zealand's giving domestic effect to the ICCPR, and it affirms New Zealand's commitment to those rights and freedoms contained in the ICCPR, and it provides that these can only be subject to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. So that's echoing the words of the ICCPR. And also Section 6 directs judges, when they're interpreting legislation, to give it an interpretation as consistent with the affirmed rights to the greatest extent possible. But it's an ordinary statute, and again, importantly, it explicitly says that Parliament remains sovereign. So when we apply this Act, we cannot disapply legislation or through our interpretation effectively repeal it. And so that's quite a tricky line for the judiciary to
It is.
Yeah. And also, even though it's setting up rights for people, it doesn't include an explicit power to issue declarations that a law is inconsistent with affirmed rights, whereas the United Kingdom's Human Rights Act which effectively copied
Exactly. Yes, that's exactly what I was thinking,
Yeah.
Chief Justice. So then how does that play out?
Well, so for over 20 years, the courts were umming and ahhing as to whether we had this power to say that legislation was inconsistent with the Bill of Rights Act until a case came before courts in 2018, came before this court in 2018, called the Attorney General and Taylor. And Mr. Taylor was a serving prisoner, and he challenged the rights consistency of a blanket ban on prisoners' rights to vote. And by a majority, the Supreme Court agreed with the Court of Appeal that the courts do have jurisdiction to grant declarations of inconsistency. So he'd asked the courts to say that this was to declare it was inconsistent with the Bill of Rights Act. And the majority of the Supreme Court upheld the declaration made in the High Court that the Act imposing the ban was inconsistent with the right to vote affirmed in Section 12A of the Bill of Rights and couldn't be justified. And what the majority said was that this was actually just simply the courts doing what the courts are required to do, which is declare the law. It is a core judicial task to declare the law. And indeed, in New Zealand, that task is provided for in our Declaratory Judgments Act. And that to issue the declaration was consistent with a no right without a remedy approach. I think that's an interesting case because there was an aftermath, which was, so we had no statutory right, and you could say that could have been seen as provocative. But Parliament then enacted the New Zealand Bill of Rights Declarations of Inconsistency Amendment Bill, which provided how the government and Parliament would respond to a declaration of inconsistency. And the explanatory note to the bill said it was to further the constitutional relationship of mutual respect between Parliament and the judiciary. And you could see that as really, a lot of our commentators talk about the dialogic model of relationship between our judiciary and Parliament. And that was Parliament responding in a very polite way to what the courts had done and creating a pathway, a statutory framework, and also standing orders within Parliament as to how Parliament will and the government will in future respond to any declarations of inconsistency.
This dialogic approach seems to be quite significant in common law jurisdictions, I feel, Chief Justice.
Yes, I think that's right. But sometimes sometimes courts don't necessarily like the dialogue, or sometimes it's not that pleasant for them. And I thought I might mention another case which might be of interest, with just a short point, but really there was a 2011 decision of our court, the Attorney General and Lee, in that case held that public servants assisting ministers to answer parliamentary questions were protected by qualified but not absolute privilege against claims for defamation. So absolute parliamentary privilege didn't extend to the public servants assisting the ministers. Parliament decidedly did not like that decision, so they responded by enacting the Parliamentary Privileges Act 2014, which explicitly states that one of its purposes is to reverse the effect of Attorney General and Lee. So
a backlash, essentially.
Yeah. So that's
a retaliation.
Your dialogue.
I just move on now to the question of remedies in public law litigation. We've seen in many other parts of the world constitutional courts and Supreme Courts kind of innovating and granting fresh remedies in the case of public law litigation. I wonder whether the Supreme Court of New Zealand has also been innovative and tried different sorts of remedies.
Yes.
And has been sort of dialogic in that way and tried to create partnerships with the other branches of government.
So certainly the Declaration of Inconsistency, I think, was probably the innovation that the Supreme Court ultimately can lay claim to. We've also recognised and confirmed in the Supreme Court the availability of public law damages for breach of the New Zealand Bill of Rights Act. That relates to a case called Bajan's case. in which it was confirmed that although there's no express provision within the New Zealand Bill of Rights Act, again, no express provision for a remedy for a breach of rights, the courts do have discretion to grant damages for breach of right. New Zealand is quite an innovative country when it comes to remedial responses. When New Zealand was created in 1840, it was a long way distant from the English courts. We didn't have many English lawyers. We didn't have any courthouses, and so the country immediately started to innovate. And I think it resulted in a kind of a substance over form response. So a reluctance to buy in too much to technical legal constructions. And I think you see that also in relation to public law in the area of judicial review, because I know that in England, and I think to a some extent in Singapore, there is a concern with the distinction between void and voidable decisions and jurisdictional fact type issues in judicial review. But in New Zealand, we have sidestepped that by giving judges a discretion at the relief stage of judicial review to decide whether or not to grant any relief at all. So in New Zealand, just to be clear, by judicial review, I know in some jurisdictions when people refer to judicial review, they mean reviewing the constitutionality of legislation. In New Zealand, I think as in Singapore, it means that it's the exercise of the court's discretion to review executive and administrative decision makers' decisions for legality and procedural fairness. Is that the sense in which you use it?
Yes.
Yes, I mean, that's how it's used in Sri Lanka as well, yeah.
Okay, so that's the sense. And so in New Zealand, even though a ground of review is made out, so you may decide that there's been a procedural irregularity or a wrong test has been applied, the courts can still decide whether to grant any relief and also what that relief should be. Should the decision be declared void ab initio, or should it be declared invalid from the date of the decision? And so I think that's enabled the New Zealand courts to avoid the kind of complex conceptual difficulties and with respect conceptual tangles that other countries have run into in relation to issues of jurisdictional fact, jurisdictional error, and the voidable dichotomy. So I think that's an area in which I think we have been quite innovative in the public law area.
So perhaps I like to follow up on your earlier point, Chief Justice, when you talked about the socialization of the tekanga.
Yes.
And I find that to be very interesting and admirable, especially with indigenous communities now being in the minority numerically in many countries around the world. It's very easy to take their customs and traditions for granted, right? And some jurisdictions ignore them altogether. In fact, I did a poll with my students here where I teach comparative law, and I asked them about what they thought about setting up a system of indigenous courts. And interestingly, many of them were uncomfortable with this idea of having the coexistence of multiple potentially overlapping bodies of law. Is that the sense as well in New Zealand? There's this comfort for perhaps concerns of certainty of the law, or is the society and the community moving towards a greater openness towards this idea of legal pluralism?
I think it's a mixed response. There are some who are very anxious. There are some who see it as a judicially imposed innovation, whereas it really is not. The English laws that came to New Zealand were brought by the piece of legislation that brought them. They came subject to existing customs and practices, and tikanga has been practiced consistently in New Zealand. And that is really why Parliament has passed legislation which has preserved tikanga within our legislative framework. And particularly since the 1980s, that really gained pace. So it is kind of what we would call a fact on the ground. So there are some people who push back against it, but the younger generation of lawyers are very receptive to it. And also Māori are becoming an ever increasing part of our economy. So it's quite strange. They're business are probably quite sophisticated in tikanga issues because they're doing business with iwi, which is what we call tribes, and they have to iwi insists that there be tikanga compliant dispute resolution processes and apply tikanga concepts in their business dealings. So it's a very mixed picture. So there's always fear of change. But what I would say is I see it more as continuity and not change. Having said that, the judiciary has a responsibility to ensure stability in a society. And so we have to be mindful of this. And we have to provide sufficient guidance. And I think if you look at our case law, you will see that it's extremely incremental and there is no revolutionary moment of change.
Yeah, so on that note, Chief Justice, perhaps we can wrap up our conversation about the society and public opinion. Since your time at the High Court, you've been recognized for initiatives that bring the courts closer to the public, so to speak. You spoke about some of this earlier when it comes to legal education. Could you reflect on the importance of public confidence in the judiciary, especially in the New Zealand context?
Well, there is a sense in which it's an international concern, really, that in our post-truth world, institutions can't take for granted that the public's going to understand or take action to protect the institutions that really uphold the constitutional settlement, and certainly that they're not going to necessarily understand the importance of an independent judiciary to the society that they currently enjoy. So throughout the world, the legitimacy of our institutions is, I think, up for debate. And people who are participating in that debate often are using misinformation rather than information to form their views. As institutions, we each have to take responsibility to make sure that there is information available about our institutions, about the work we do, and about the role that we play, so that public debate is properly informed and so that information rather than misinformation takes its place. So I'm very active in taking steps to support open justice, so that we support the media to do their work properly, reporting the courts. We also have various initiatives to enable the public to more easily access the work of our courts. Our courts are very open to the public. We have the media are permitted to film proceedings in accordance with guidelines that we have. So it's, and fortunately or unfortunately, most of their effort is spent on criminal trials. They're not so interested in the civil. But there's a high level of public coverage of the work of the courts, and what we want to make sure is that that coverage is accurate as it can be.
I just have two quick concluding questions, if I may. One of which is whether you allow third parties to intervene in litigation. Is there a practice? For example, in a Bill of Rights claim under the Bill of Rights Act, would you allow a third party, whether it's an individual, an organization, or even the Human Rights Commission, to intervene and place their views before the court? And my second question is on the sort of value of comparative law. Does the court cite foreign jurisdictions very often? And do you refer to any Asian or African jurisprudence in your judgments?
So starting with the intervention, our Human Rights Commission has a statutory role of intervening in proceedings where human rights issues are at stake and where it can be of assistance. It has a statutory role. It doesn't have a statutory right. So the issue for the courts with the Human Rights Commission and with third-party interveners is, will it be of assistance to the court? In human rights issues, we haven't seen the most common intervener is the Human Rights Commission. In most cases, the exception I've placed on that is that when we have human rights issues rising in the criminal jurisdiction, we quite often get criminal legal organisations seeking to intervene, such as the Criminal Bar Association. And also sometimes Te Hongaroa Māori, which is the Māori Lawyers Association, because we have in our society, we have a societal problem, which is that Māori are massively overrepresented in our criminal justice statistics. So Te Hongaroa Māori, the Māori Lawyers Association, have a really significant interest in a lot of criminal law issues. So we are generally permissive of third-party interveners if they will be of assistance to the court, but we do take into account whether it's going to add unjustified cost and burden to the other party. So sometimes also when it's not just third-party interveners, actually, we in fact invite intervention and sometimes appoint counsel to assist, because the decisions of the court are important. They settle the law, and we want to make sure that we understand the law, the way the law is currently operating, and the implications of decisions before we issue those decisions. And I think third-party intervention is very valuable in that regard, as can be counsel assisting, amicus. So that takes neatly to the next question, which is international jurisprudence. So yes, we've got a deep interest in comparative law. Once upon a time in New Zealand, we only ever really looked at English cases. That was to the exclusion of New Zealand cases until about the 1950s. But increasingly, we find we look to other jurisdictions. We look to Singapore a lot.
Interesting.
Yeah, a lot, especially in the private law area, in contract law and in court. And in fact, if you analysed Singaporean law in relation to the law of negligence, and in relation to the law of admissibility of extra contractual documentation, for instance, you'd see that New Zealand's law and Singaporean law is very aligned. And that's not a coincidence. We've been looking at each other's law for a while. And so we're very interested in what's going on in other jurisdictions. So we've moved from purely looking at the United Kingdom. We now look at Australia, Singapore, less so America, because its law is evolving in a particular way. We look at Canada quite a lot in the Bill of Rights area, because our Bill of Rights Act was constructed in a way consciously that the people who drafted it had an expectation that we would look to Canadian law under its charter. And so some of the concepts that they used in the framework of the enactment are common. So we have a broad array. And I'd say the thing that's been increasing the last 10 or 15 years is access to the decisions of the United Nations Human Rights Committee and the European Court of Human Rights, because they're dealing with, our Bill of Rights Act, of course, picks up the ICCPR rights, and that's what the United Nations Human Rights Committee is dealing with, and the European Convention on Human Rights is also picking up the ICCPR. So there's a lot of commonality there, and we learn a lot from it. So we're looking around the world.
Well, Chief Justice, you've left us, or leaving us rather, with a lot of rich insights, and I just wish that you could come talk to our students at some point, because this is something that I think would be of particular interest to them, not just as young lawyers potentially going to practice, but as sort of intellectual interest. And we have this CALS Chai Chats mark here, which you probably can't see.
Oh, yes, I see that.
We'll try and get it to you at some point. But thank you very much for your insights and for joining us on this edition of CALS Chai Chats.
My absolute pleasure.